we are going to talk about a legal term called universal jurisdiction. This is a really important way to get human rights cases prosecuted. It refers to the idea that a national court may prosecute individuals for serious crimes. So it's the idea that a national court can prosecute individuals for serious crimes against international law, such as crimes against humanity, war crimes, genocide, torture. The list is expanding. So universal jurisdiction, very simply put, you can bring a case to a court in any country that is accepts universal jurisdiction for crimes that occurred outside of that country, because those crimes are considered of such a bad level, such a high level, that you can demand that a nation's courts, a national court, prosecutes. So it's based on the principle that such crimes harm the international community or the international order itself, which individual states may act to protect. Generally, universal jurisdiction is invoked when other traditional bases of criminal jurisdiction are not available. For example, the defendant is not a national of the state. The defendant did not commit a crime in that state's territory or against its nationals, or the state's own national interests are not adversely affected. National courts can exercise universal jurisdiction when the state has adopted legislation recognizing the relevant crimes and authorizing their prosecution. So what does that mean? It means that you're going to have countries that are signatories to Convention Against Torture, Inter-American Convention to Prevent and Punish Torture, Genocide Convention. Every country that has signed these conventions has agreed that these are heinous, horrible crimes, and therefore they can prosecute these crimes in their own national courts, not at the European Court of Human Rights, not at the ICC, but actually in, for example, and we're going to look today a lot at Germany and France and Switzerland in these national courts. The other way that the national courts can prosecute and have the jurisdiction, the legal authority to prosecute, isn't just that they're signatories to these documents, but they can have their own legislation that has been passed through their own parliaments, where they say, we recognize that these crimes are heinous. We give our courts the legal authority to prosecute them on our domestic territory. And we're going to see at the end of today that this legislation was just passed in Ukraine. So a number of countries in Europe have passed this, and last year, Ukraine, March of last year, Ukraine also passed such legislation. A range of states' national laws provide for some form of universal jurisdiction. So domestic legislation empowers national courts to investigate and prosecute persons suspected of crimes potentially amounting to violations of international law, regardless of where the crime was committed, the nationality of the suspect or the nationality of the victim. So let's understand this, that you can have well, let's use the example of Germany, because most of the universal jurisdiction cases arise from Germany. You will have a Syrian refugee who's come to Germany and has sought refuge as an immigrant. He has then been spotted, perhaps, by another Syrian who recognized him from committing torture or other violent acts during the conflict in Syria. That individual or number of Syrian victims can come together and bring this to the investigating authorities, the police in Germany. From there, the German prosecution office decides whether they're going to accept the case. And in almost every case in Germany, they have, and this will go forward, and you will have a domestic trial that will investigate the crimes that occurred on Syrian territory committed against Syrian individuals by Syrian military, special forces, but anyone. So it's the matter, the turning point that creates this is the crime. is the severity of the crime. That is how you get into the court. If the crime is so severe, such as torture, severe human rights abuses, um, war crimes, then it's triggered. The mechanism of universal jurisdiction is triggered, and you can begin an investigation and a prosecution. So Germany, in fact, has no involvement in this. They weren't involved in the conflict in Syria. The citizen, the person who's bringing the case, most often is just a refugee, and often is brought against a refugee. So no German citizen is in fact involved. The purpose and point of this for Germany is that they're protecting the highest international law standards that they stand by as signatories to numerous conventions, as well as to having a triggering article in their own legislation that says that they uphold international law and human rights through all of their legislation as well as their courts.
Sounds good.
So Amnesty International reports that in total, 163 out of 193 UN member states can exercise universal jurisdiction over one or more crimes under international law, as such crimes or as ordinary crimes under national law. So they can bring these 163 out of the 193 UN member states has the authority, either under international law that they're signatories to, or under their own domestic laws, which trigger universal jurisdiction prosecutions. So that's a large amount. And I'm now going to go into the PowerPoint, and I'm also going to discuss why last week last month, December, yes, that we met, we discussed US triggers. One very important point to remember is that the United States does not exercise universal jurisdiction. That is why we have to leap through all of these Alien Tort Statute, Torture Act, all the US legislations that have been created to fill the gap of universal jurisdiction. The reason that the United States does not accept universal jurisdiction comes from a historic feeling that the courts should not engage in diplomacy, that they should not be involved in judging different countries, and that this could take away the authority of the executive and the legislative powers. The biggest person who was against universal jurisdiction and really very firmly blocked future application, and interestingly, this was about a little bit before Alien Tort Statute became a vessel to bring these sort of cases, was Henry Kissinger. Henry Kissinger, there were numerous attempts to apply universal jurisdiction in the United States during the Vietnam War, the conflict in Cambodia, and it was Kissinger who very, very vocally came out against this, saying that it would give the courts too great a power in terms of the balance of powers in the US, and that this was dealing with foreign nations is the role of the State Department and the executive authorities. So again, when is universal jurisdiction applied? It's applied in the cases of war crimes. So all of the definitions that you would find in UN conventions and statutes, and all of the developing law that's come out of the ICTY, ICC in defining war crimes, crimes against humanity. So again, this is a broader definition, and genocide, and of course, torture. So in terms of where universal jurisdiction comes in, it comes in the most serious crimes. You're not going to have a universal jurisdiction case for, let's say, prohibitions on free speech, or robbery, or any sort of more civil right. It has to be a significant human right that really puts that human's life in danger. It's expanding, and I have to say again, this is Germany, and recently Switzerland very much expanding that. And there is a chance that eventually there will be a broader application, but it's really looking at what is a crime that is so deplorable and so horrible that it's universally condemned and can be universally prosecuted. So these are really the most serious crimes. So universal jurisdiction is the ability of the domestic system to investigate and prosecute these crimes, even if they weren't committed on the territory. So again, as I said before, the relationship between the prosecuting country is minimal, and in most cases non-existent. Looking hypothetically, if you had decided to bring such a case in a jurisdiction like Germany, you would have to trigger it by going to the commence the prosecution by going to the investigating authorities. It would have to be investigated first and then be taken to the to make a decision to have the prosecution opened by the state prosecutor's office. So these are the treaties that allow and oblige states to use universal jurisdiction. Again, the United States is a signatory to these conventions and these treaties, and it's been there just based on their own political, just one second, political decision to not apply universal jurisdiction. But these are the most serious and encompassing laws: the Geneva Convention, Convention Against Apartheid, Convention Against Torture. And when we say torture, that means, I mean, that gives a breadth to cases that can be brought, because there's torture as part of conflict. There's torture, as we're going to see later when we discuss Ukraine. There's torture also being run by numerous governments. There's a Saudi case being brought now in Germany for torture. And then you have the Convention Against Enforced Disappearance. So if you are looking to bring a case in under universal jurisdiction under any of these conventions or treaties, you should have a good grasp of, does this cover your fact pattern? Does this cover the facts that you're looking to prosecute? For example, if you have disappearances occurring in any part of the region that you're working as a human rights advocate, will this convention cover you? Are all the standards met? But then you also have international customary law. So it means crimes that the international community will find deplorable, such as crimes against humanity, genocide. And then you have the national. So you have the German laws that condemn these sort of crimes within their own legislation that you can introduce and use. So it's really important. And oh my gosh, the prosecution office in Germany is amazing. They're very open to bringing these cases, and it becomes a matter of building relationship with that prosecution office. What you would need additionally is somebody, let's say you are looking to prosecute under universal jurisdiction a crime committed, let's say in Ukraine, you would have to have both a victim in Germany, and you would have to have also the perpetrator. So if it was a member of some special forces, he would have to be there. And that does not mean he has to be a resident. That does not mean he has to be a citizen. He can be, in fact, just flying through. He could be just stopping on his way to another country and be, if the authorities are informed, he can be arrested. He or she can be arrested. So it's very broad. It's if you're going to be using this as a tool to push for enforcement and punishment, you would have to be very careful and very conscious in terms of selecting who the individual who will be bringing the case. So you'll need a victim in country, be it in Germany, Switzerland, or France. and I will go into a number of other cases. It's really broadening, and um, it's become a tool of Europe, I would say, more than anywhere else. The other place that you see it being used a lot is in Latin America. Um, the places I mentioned that does not do it is the United States. And one the case that we're going to go into, and that has been sort of consistent, the UK is very reluctant. They use numerous laws and complexities and nuances to prevent ever having to hear universal jurisdiction cases. Although they, unlike the US, do not outright say we don't use universal jurisdiction. They say they use it, but they look for numerous loopholes. So the best places to look to bring these cases, for example, I worked on one case in Finland. So you have Finland, France, Switzerland, Sweden, um, Spain. Spain is another country that is very, very open to bringing these cases. So it's looking to see where you have a potential victim slash client that you can assist in getting justice for, and where you have a potential perpetrator either entering or residing. So universal jurisdiction acts as a safety net. So when the territorial state is unable or unwilling to conduct an effective investigation and trial. So in terms of the Syrian cases, they found that due to the conflict in Syria, it was not possible to have trials examining and prosecuting perpetrators. And also, equal to the inability for the courts to effect justice is also the unwillingness. So if you have a system that is not interested in actually prosecuting torture, that has rejected cases going forward, then you're able to bring a case under universal jurisdiction. The very good thing about universal jurisdiction is that it reduces the existence of safe havens where a person responsible for grave crimes could enjoy impunity. So, for example, think of after the Second World War, when numerous Nazis fled to South America. You had them able to escape prosecution. They were hiding. Those countries weren't willing to hand them over to Israel or to the US. So those people were able to reside safely. The goal of universal jurisdiction is that wherever you are, if you've committed these sorts of crimes, you will be prosecuted. And again, I think most of you were at the last session that we had. Well, I underline over and over that it's very difficult in the US and it's not utilized. The other tools that I taught you in the last session are the means to bring similar charges, but for these same types of crimes in US courts. Okay, now we're going to discuss quickly the ICC. So the ICC does not replace this. The slowness of the ICC to examine many of these cases does not matter. Every country can jump in. Every country that uses universal jurisdiction can come in when they, as a country, have the right to investigate and prosecute these crimes. So it's not limited to the ICC. It's not limited to the Rome Statute. If you have the ICC opening an investigation, let's say to Afghanistan, which they've switched examining US forces and UK forces in Afghanistan to now only examining the Taliban. They've stopped looking at the international perpetrators. So they're only looking at the Taliban. If you have in Germany a former Taliban fighter and you have a victim of acts by the Taliban, you can bring that case without any problem in a German court or in a French court. And that doesn't at all have anything to do with the ICC. You do not have to wait and see what's going on at the ICC and wait to see when they're going to bring their case. You have absolutely every right to go forward with a investigation and a prosecution, even if the ICC has opened an investigation into that conflict. One of the really uh, big reasons that, and we'll get into this a little bit later, that Germany has been taking this on is because both China and Russia have blocked any examination into the crimes that occurred in Syria. So you have entities that were established, and I'll get into this a little bit later. There's an international mechanism in Geneva that has the authority to investigate crimes in Syria. You have numerous groups. There's a very big group in Portugal that is working on investigating the crimes in Syria. In a normal incident, in a normal case, for example, when the Yugoslav Tribunal was established, the ICTY, the moment the ICTY was opened, Germany, which had been prosecuting and investigating the crimes that were occurring in Yugoslavia, because they had admitted numerous war criminals into the country as refugees. They had open cases. What they did is they closed those cases and sent them, including the perpetrators, to The Hague, to the ICTY. So for example, the Tadic case, which was the first case prosecuted at the ICTY of a Bosnian Serb perpetrator, was a case that was handed over to the ICTY by Germany. And he was prosecuted. It was a long case. It established a lot of laws for the Yugoslav Tribunal, but it's not possible to do that now, because Russia and China have blocked any court from examining the crimes occurring any court being established from examining the crimes in Syria. Germany has nowhere to hand these cases. So what they're doing is going ahead, and same in France and other countries in Europe, Sweden, they're going ahead and they are prosecuting these war crimes cases in their own jurisdictions. What is the effect? Like we talked about the last time about how the US is prosecuting these crimes, it's a lot cheaper. You're not asking for millions and millions of dollars, hundreds of millions of dollars from the United Nations and international community to set up a court to focus on one region. The other thing is, and this is where the US becomes different. The US historically and factually always gives much larger sentences than Europe or international courts. So as I mentioned last time, an immigration fraud case, which was in fact a war crimes case, a torture case, the individual was given 30 years prison. I worked at the ICTY for 15 years. I think there was maybe one sentence that was that high, and these were really bad war criminals that we were dealing with, and leaders, senior members of the Croatian, Serbian governments. So in Europe, like at the international courts, you have much smaller sentences. So I think we'll go back through, but I think that the last Syrian case in Germany, I think he was only given 7 years sentence in prison. So there's a lot of complexity and reasons why there's good things about having a court established internationally to examine crimes versus national. Another problem that you have with these national prosecutions of universal jurisdiction is, for example, the ICTY became a repository of all of the witness statements of all of the historical crimes that were committed in the former Yugoslavia. So you have one place that you can go to, and you can pool when you're having another case that you can pool on and use for further cases and later cases. And you also have the significance of when you have people who deny a genocide occurred, for example, in Srebrenica in Bosnia, you have I can't, millions and millions and millions of statements and pages and documents and orders all in one place that can be brought forward if that challenge is public. So you don't have that with national prosecutions. So if you have a prosecution of a Syrian that's a member of one part of the military in Swedish court, and then you have a prosecution of another member of that same military unit in Germany, there's of course going to be sharing. There's going to be meetings between the lawyers, between the prosecutors. It's there's going to be some cohesion, but there's not going to be a single area. There's not going to be a single place that you can gather all of this information and then build a record of what was that military unit doing? How were they prosecuting? How are they perpetrating these crimes? And who was in charge? So it becomes much more difficult to build a big, let's say you were building a case against Assad. It becomes much more difficult to do that because you have evidence in one place, you have evidence in another place, you have it in this language, in that language, in Spanish, in French. So you have to then, if there was a court set up in the future, or let's say if Assad was arrested somewhere in the future, you would have a big task of gathering all of that information that was brought in through all of these different courts and these different hearings, which is a challenge, and it's a shame. You have this international mechanism in Switzerland, in Geneva, that was set up because Russia and China didn't want to have a court examining it, but it's a temporary institution. And all that it's doing is just gathering evidence of everything that occurred in Syria. And because there's no chance of there being a court, it's putting that evidence and sending it in bundles and binders over a cloud to a court in Germany or to a court in Sweden. So there's not one single place that the laws that come out, the facts that come out in Germany are not going to be sent then back to Geneva. So there's no one single place that information is gathered. So that is one of the sad things, the disadvantages of universal jurisdiction, is that if you brought a case of torture, for example, in Russia, you brought that to a German court using a victim and a perpetrator that were both on German territory, you would not have like a buildup. You would not have a continual area, a place that you could continually bring and prove more cases. You'd have to look, oh, now we have a perpetrator in Sweden. So you'd have to basically restart the whole process and investigation, even if the two individuals were from the same military unit or police unit in that you're examining. The second fact, the first fact is a problem that applies to all these crimes, and it doesn't just apply to universal jurisdiction. It applies to the cases that you bring in the US under Alien Tort or under a Torture Act. It applies to crimes that occurred that are being prosecuted in the ad hoc courts, at the ICTY, at the Special Court for Sierra Leone, anywhere. You have old crimes that occur far away from where they're being prosecuted. I worked for 4 years in Cambodia. I worked there from 2010 to 2014, and we were prosecuting crimes that occurred in the mid 70s, 1970s. So this is, I mean, the further you get from your crimes, the more difficult. That's why at least what Germany is doing right now is they're right now prosecuting as soon as possible the crimes that occurred in Syria. So you have a real advantage going forward with universal jurisdiction. If you were to wait for a court to be established by the UN, that could be in 20 years. Where does this come into play? There's a lot of evidence where its age isn't as significant. For example, when you're doing a military command case, you have, most times you have military orders, you have witnesses, you have people on the ground. When you have a case of sexual violence, when, for example, sexual violence is used as a crime against humanity, or as was found in Rwanda as a form of genocide, um, it's very difficult. I've worked on numerous of those cases, and it's not just the trauma of the individual and difficulty for them to come and speak about something that happened 10, 15 years ago, but it's also the evidence proving sexual violence occurred systematically is, you can have numerous witnesses, but you won't ever have the forensic evidence. And that's something with these cases in the ad hoc courts at the ICC, and I think also part of these universal jurisdiction cases, there is a tendency to be more, to be less demanding than you would if you, for example, you had a rape that occurred in on the streets somewhere in Germany immediately, where you would have to prosecute that, show that the woman or man went to see the police, got a rape kit, all of this was done. It's much more understanding in these larger cases towards that, but that's a negative. That's a very difficult thing to deal with, is the proof, the evidential proof, as well as the ability to gather this evidence when when there's a lapse of 10, and in the case of Cambodia, 40 years. Very interesting negative. This wouldn't apply so much to any cases coming out of Russia. For cases coming out of Russia, there might be more of a feeling of a Western bias, but there's definitely a feeling of colonial justice. So when you have a case of a Liberian war criminal for example, it was in the UK. The UK brought a case against the wife of Charles Taylor. So Charles Taylor was a horrible president of renowned war criminal in Liberia, who committed crimes in Liberia and Sierra Leone. His wife was involved, his former wife. I think he had 6 wives. One of his wives, Agnes Taylor, was living very well, beautifully in the UK in a beautiful home. And a case was brought against her in British courts. The feeling that a Liberian court is not able to do this, and you have also in Finland a Liberian case, that it's left to these Western developed nations, because, for example, in Liberia, you don't have a conflict right now. You have supposedly functioning courts. So why are these cases not being prosecuted there? Is it really becoming that it's necessary for a Western developed country to step in? So it leaves a little bit, in some of these cases, a little bit of a bad taste. We'll go through one of the cases a little bit later, the Finnish case, where you had the Finnish investigators and lawyers and judges all flying to Liberia, all Finnish, blonde, tall men with, office clothing, kind of safari clothing, sitting and establishing a court in an African country where you have all the witnesses, victims, everybody is African, coming in front of them. So it has a little bit of a universal jurisdiction, can leave a bit of Western courts judging and making decisions for less developed countries, or countries that aren't falling under their Western democratic ideas. Then you have political indictments. The country that's most known for and been most accused of this is Spain. So you will have you had a Spanish prosecutor who just loved to indict. So I remember, even when the ICTY was functioning, he issued an indictment against Milosevic. So they were hoping that Milosevic at some point would fly through Spain so that they could arrest him. And during the Iraq War, you had numerous countries, in Belgium specifically, trying to indict, pushing indictments of President Bush, Dick Cheney. So this was, as much as these people might be perpetrators and criminals, and, and you also had against President Sharon, numerous, but Netanyahu, numerous people who European countries might find to be criminals. You had these countries trying to create political cases. So, and when I say political case, as bad as somebody as George Bush might be seen, this isn't what universal jurisdiction is about. Universal jurisdiction is about getting a victim. So if you could have a victim of and show the direct links between orders and laws that connect, let's say, a US military official or a CIA officer all the way to President Bush, I think that there would be a legitimacy and a chance that a case like that could be brought. For example, also, if you had for Russia, if you were able to show the legal links, the chain of command to a senior commander or political official, to a crime of torture that occurs or a crime against humanity that occurs on the territory, that's not a political indictment. That is a serious universal jurisdiction case. When I use the term political indictments, that is when the country, for example, Spain, would just issue these indictments without even having a victim filing that. That would be a filing by their prosecution office. So that's different. So one important part of this is to discuss what happened with President Pinochet. And again, I'm going to start discussing, and I think this is the first instance where you really have a reluctance by the UK to prosecute somebody. And you can see how then what happens with the with this case and how it's rejected, how the UK doesn't wish to prosecute it. So he was indicted by a Spanish magistrate, Baltasar Garzon, and Baltasar was very well known for pushing these human rights violation cases. He was indicted for the violations committed in Chile, and then he was arrested in London 6 days later and held on house arrest. And historically, you guys are also young, but General Pinochet was a very close friend of Margaret Thatcher. And he had a residence in the UK. He was very close with her. He was also friends with George Bush in the United States. So George Bush and Margaret Thatcher got together and demanded that the British government release Pinochet. They argued that he should be allowed to return to his homeland rather be sent to Spain. So Chile did have, by this point, functioning courts. There was no sign that they would not prosecute this. So he continued to argue because the British legislation and judiciary were leaning towards sending him to Spain. He argued that he was immune under a States Immunities Act, which protects state leaders from being sued in the UK. And this is now something really relevant. If you have an agreement between, if you have an official law in Germany or in Sweden that does not allow sitting presidents or former leaders to be prosecuted, I don't think any of those countries have that. I think they have an immunity of current leaders. But if you have that, then you're going to run into a problem because the government will not be able to apply universal jurisdiction. It'll be prohibited by that national legislation. So the Pinochet case resulted in 16 months battle in the House of Lords. He was sent back to Chile and he was indicted in Chile, but he died before his trial. So this was sort of the first time that a very senior leader was held without in a country that's not his own for committing crimes in a foreign jurisdiction. he was held without a warrant or court request for extradition from his own country. And this was the first time in international law that this happened. In the end, it shows where politics can be a problem. When I was going through my notes to prepare for today, it did occur to me that, for example, Germany has been quite um, how do I phrase this? Not interested in sort of pushing back against Russia on numerous things, and it comes into, whether it's with the Ukraine not wanting to take a stance, whether it's to do with a historical aversion to enter conflict because of the role of Germany in World War II, or is it, there's politics around Nord Stream agreements? Who the fuck knows? Sorry, but why Germany is taking a very cautionary and not very exemplary role with Russia, and whether that would be a problem in bringing cases in Germany, I don't know, but it's something to consider. Is a nation's politics. The UK at that time was very tied and very committed to Pinochet. So politics came into play here, sadly. And that's why he never actually ended up facing trial. As I mentioned, universal jurisdiction is not popular with the US. The US will not apply it. Has the universal jurisdiction been used against the US? Yes. There's been numerous, and I here have a list, and I'm also in a second going to discuss a case that was just now filed against the US for crimes in Yemen, in Germany. The universal jurisdictions being brought in a German court for crimes committed by the US military in Yemen. So you have here cases in Belgium, France, Germany, Spain, Switzerland. All of these cases are coming out of the war on terror. There were numerous these attempts to arrest people, involvement in grabbing people from Iraq, from these are numerous. I have two Iraqi cases here. So you have all of these cases that the US has been brought to. Unfortunately, there's not ever been a decision found against the US. So one of the things that stands that protects the US in these cases is that you have the ability by the United States government to say, are you really going to say that we don't have courts that are functioning, that we don't have courts that are were held up as a model for the whole world? If we want to bring a case against Donald Rumsfeld, we just need to look at the evidence. Now, is that true? I don't know. There's a lot of politics here as well, but this is definitely something to think about and to look at, that the US has been dragged through these courts, and there's no reason why officials from the Russian government or from any other country's government would not find themselves in the same place. What you would need, for example, here in Belgium, you have Iraqi families. You would need somebody who's a victim of Russia, Belarus, any country present. Saudi Arabia, for example, is one present in a country that prosecutes under universal jurisdiction. You would need to have that individual either resident there, passing through, refugee at any point entering. So at any point that they're stupid enough to fly into a country where there's an open investigation and an indictment against them, they can be arrested. So that's something to keep in mind. So although the US or numerous countries don't apply universal jurisdiction, it is still possible to bring a case against those countries that don't use the universal jurisdiction under universal jurisdiction in mainly European courts. I'll discuss quickly one. So this was Germany versus Ayad al-Gharib. This was a Syrian secret police officer who was charged with aiding and abetting crimes against humanity for his role in arresting and transporting protesters to an interrogation center that's known for torture. He was found to be guilty of crimes against humanity. So, serious crimes that resulted in torture of Syrian victims. So, you had a Syrian victim introducing this. I believe Ayad Gharib, and I might be mixing this up, I think he was spotted by a Syrian victim of his crimes. And that's usually how, once the community of victims becomes aware that a perpetrator's in the country, there's usually the first thing they do is they have to bring that to the attention of investigators and prosecutors. So he was sentenced to 4.5 years, which in the US, he would be sentenced to much, much, much more. But this was the first war crimes trial that came out of the crimes in Syria. And again, there's nowhere else that these crimes are going to be prosecuted other than in domestic courts, because there's no international body that has the authority to prosecute crimes in Syria. So this is interesting. This is a Finnish court became aware by an NGO, a Swiss NGO, informed the War Crimes Office in Finland that there was a senior official in, his name's Gabriel Masakoi, present in Finland, and that he has committed numerous crimes, murder, war crimes, crimes against humanity during the Liberian Civil War. He was a head of a militia that was under Charles Taylor's forces. One of the things that I don't have notes here, it's a very interesting and quite upsetting in terms of the international court's fact, is that Gibril Masakoi was investigated by the Special Court for Sierra Leone. So the Special Court for Sierra Leone was an independent court that was established by the United Nations, the way that the ICTY was, the way that they've attempted to get a Syrian court open, which they never did, like the Rwanda Tribunal. So this is an independent court that was investigating crimes. Gibril Masakoi served as a witness against other people, and he testified against other people. The prosecutor's office in The Hague, where this court was based, decided not to prosecute him. They said that he had been cooperative, that he had helped them, so that there's no reason to prosecute him, and he was allowed out. That was a very, at the time, confidential decision, but it was made. And that argument was brought by the defense when he was arrested in Finland. The defense said this man was cooperative with the Special Court for Sierra Leone. They decided not to investigate him. Why would we, why are you now looking at my client and investigating him? And the Finnish government said, we're not under the authority of the Special Court of Sierra Leone. We are under our own laws. And under our own laws, we recognize that these horrible crimes, torture, crimes against humanity, all fall under our jurisdiction. So we are going to prosecute him. And that this is the prosecution that I mentioned that left a little bit of a bad taste in my mouth, where you really saw the Finnish European lawyers and judges flying out to Finland to investigate and flying out to Liberia to investigate and to hold some court sessions in Liberia. But he is a horrible guy who's been found guilty. So, in the end, the result of universal jurisdiction, this is a very important case because universal jurisdiction here has trumped an ad hoc decision. So it has shown that a nation, if it makes that decision to prosecute, is not bound by the decision of a UN court, that they can act on their own if they find that those crimes are so horrible that they fall under universal jurisdiction. So as we mentioned, now that the US is not being brought under universal jurisdiction, three reasons for that is transnational complementarity, that the US, if they can prove that they're investigating the crimes in question, then they will not that they cannot be brought to a foreign court. Second, that it's a subsidiarity argument, that the case should be prosecuted closer to where it occurred. And the third is immunity, if it's the immunity of a sitting government official. So this is the way the US has managed to get out of their universal jurisdiction cases. However, in April 2021, so last year, two Yemeni men alleged that their relatives were killed in an American drone strike, and they've appealed their case to Germany's highest court. They've urged Germany to ban the US military's use of a military base southwest of Frankfurt to help control such attacks. The appeal was filed by the European Center for Constitutional and Human Rights on behalf of this Yemeni family, of these two Yemenis. So this is important, that oftentimes the best approach, if you are a human rights group, is to partner with another human rights group, be it in Germany or Sweden or France, wherever you feel that you have a strong case to build for human rights violations. So that an essential part is to do research, because that group can then do all of your filings, can begin to prepare the case and work with the victims groups that you're pushing justice for, and ensure their representation. So these Yemenis allege that their relatives were killed in a drone strike in 2012. So this has been, it's now 2021, and it's reached the appeals court in Germany. So that's a sense of how long the battle was. You have the crime occurring in 2012, and then you had it going to a federal administrative court. It was weakened decision by the Munster administrative court, which ruled that German government had only partial responsibility to ensure the drone strikes coming out of the military bases, US Ramstein Air Base, were carried out in line with international law. So the German court at this point defined it, I know it's in appeal, but at that point it defined it as being not just a universal jurisdiction case, but a case of Germany's own responsibility in the drone attack. So in 2020, the appeal court in Leipzig ruled that German agreed with the lower court, but based their decision to not proceed by saying that German diplomatic outreach to the US over strikes was sufficient, regardless of international law. So it pulled a political decision. It decided that Germany was dealing directly with the US over this, and it was not essential for German courts to step in and to examine this. They noted that the German government had taken steps by communicating with Washington, and that Berlin had made an effort to ensure that the plaintiffs' rights were protected. The US's defense in this was that the military had to use, the US military had to use conduct operational level planning, monitoring, and assessment of assigned air power missions, but it did not, that this attack was fell under counterterrorism activities was the argument. So it was able to take this case a little bit further. The European human rights group that was working with the Yemenis was able to take this further. And in their appeal, they said the 2020 court decision should be overturned, because German courts were obliged to protect the plaintiff's right to life. So this case has now gone into appeal. The group appealed that the Ramstein's significance was much greater than the court assumes, and that the US had direct liability in the deaths of the people in Yemen, and therefore had to be held liable under international law as a grave breach of international law. They demanded that universal jurisdiction apply. So, as we mentioned, dealing with Syria, these cases have all come out of the problem that there is no court examining Syria. In Syria, there's been enormous war crimes on every side, and everything to horrible destruction of cultural property, loss of life. So at the moment, the only way when a set of crimes is not being examined and there's no court that is examining those crimes, the only way that they can be brought is under universal jurisdiction. So on January 13th of last year, a German court found another Syrian responsible. His name's Anwar Raslan. He was a former security official in Assad's regime. He was found guilty of crimes against humanity. He was charged with overseeing torture. So this was a case based on the torture of thousands of prisoners in Syria, many who were also sexually assaulted or killed. This case was also brought and organized by human rights groups in Germany, representing the victims. So again, it is essential that if you have a victim or you have a case against someone, that you work with a human rights group in the country where your victim is based. Raslan's trial reflected an important and growing trend in international politics, the assertion of universal jurisdiction by domestic courts. In Germany now, it has become absolutely normal. There is no reluctance in terms of investigators opening cases or prosecution's offices prosecuting and indicting. Germany has accepted its place in this movement. It is leading the movement of universal jurisdiction, and it's only growing now. And it's only places that I would say that it would be a restricted use of universal jurisdiction is where you would have an international court operating in that field. So if you had an ad hoc court examining, for example, now there was a new one set up 3 years ago in The Hague that only examines crimes that occurred in Kosovo, in this contested Serbian Kosovo region of the former Yugoslavia. So I do not believe that Germany would ever enter into examining cases that fell under Kosovo's jurisdiction, under the Kosovo court's jurisdiction. What they would do is what they did with the ICTY and transfer files and evidence to that court. But in all other instances, it really is a really significant use of universal jurisdiction is occurring right now in Germany. Numerous research has looked into why is Germany doing this? Is it the history of Germany? One thing that many people don't know is that Germany is the main contributor to the International Criminal Court financially. There's Germany and Japan, interestingly. The other reason is sort of a historical sense of war crimes and justice, guilt. But there's also this move that is being driven by migration. The fact that there are so many Syrians who were allowed into Germany across the borders has changed how the tactics that individuals and governments adopt to uphold international law. So this universal jurisdiction allows the court authority to decide on these specific cases and legal questions. And this is a domestic legal system, and it's being triggered by the presence of Syrians in Germany. So understanding why it's developing in Europe, and also another place that's very strong on applying it is Sweden, which has also accepted enormous numbers of Syrian migrants. So although Raslan, this commander from Syria, did not commit his crimes on German territory, not one of his victims was German. The actions did not affect German security in the least. They were able to convince the German court to hear the case because it and to invoke universal jurisdiction because of the inner interest to international law and to defending and protecting international legal standards and international human rights. The first cases of universal jurisdiction were very early, and it was established historically as a way to punish maritime pirates because these were crimes being committed outside of any territory on the high seas. So the concept of universal jurisdiction was born out of this. When it first became activated was one of the first instances is the trial of Adolf Eichmann, who was a Nazi official who oversaw camps and significant crimes committed during the Holocaust. They were prosecuted under universal jurisdiction in Israel. And that was in the 1960s, in the early 1960s. So that was the first trigger, was using a country, that, for example, Israel, which had not even existed during the time that the crimes committed by Eichmann occurred. They were able, under universal jurisdiction, an understanding of crimes against humanity, war crimes, and his acts in that, to prosecute him. And this was the birth, and seeing this in Israel is spread to the idea of universal jurisdiction being used, spread to back to Europe. And Germany is the country that most frequently asserts it. Data indicates that, I think since 5 years ago, that Germany has opened over 650 cases based on universal jurisdiction. Spain, 350. And behind these two countries are Canada, France, Sweden, and the United Kingdom. So Canada is also a very interesting one. They have a very strong war crimes prosecution office. They like to use universal jurisdiction. So for you as human rights groups looking to bring any case, you are not just restricted to your restriction is only where is my victim and where is my perpetrator? Where are they located? And then you can go over that hurdle. Even in the US, you can apply the tools that we learned in our last session, but here you can go broader in using universal jurisdiction. So Canada, France, Sweden, United Kingdom. And then you have numerous universal jurisdiction cases in Argentina, Senegal, South Africa. Latin America right now is booming with protecting human rights. There's been a success of the Colombian court. And just, I think, 2 days ago, a Guatemalan court came out with a significant human rights decision. So it's really looking to see where is the person, where is the individual who represents what military unit or police unit you believe has committed these crimes, where are they present, where are they going, and where are the victims of these crimes located. One thing that came out of research into universal jurisdiction that's been conducted is that it's very unlikely that a case will be launched against a country's military allies. So the case that we just discussed with the two Yemeni brothers, the US and Germany are close military allies. Would Germany ever want to prosecute, allow for a decision, and this is still being tried, this is now in an appeal. Would this still want to, would a German court be allowed to enter a judgment against the US government for a base that's based in Germany that they run together? So it becomes tricky, and the sad fact is always, and having worked in international courts for so many years, politics is significant, and it's something that can always, help or hurt your case. Uh, there may be, we discussed in a number of classes back, trainings back, the Navalny case. If you had somebody who had been a victim because he was a part of that political movement or something based in Germany, and you had somebody who was involved in the torture or any act against that person in Russia, it's very likely, looking at how renowned these cases are in Europe, that there would be some sort of examination. Again, as I mentioned, I don't know what Germany's doing right now, and how they're acting, and whether there would be a political step to prevent something like that. But then there's always the options of, if you have somebody in Canada, if you have somebody in Sweden, the world is basically your open to you to bring these cases and to find which countries are the most open to and least likely to be politically motivated in their decisions. I have seen Spain, the prosecutors in Spain, not care at all what their country's politics are, and push ahead with their cases. So if somebody's on vacation in Spain, you might have a very good shot of getting them investigated and indicted. So we'll go through the steps that a victim would take. So now that this can be a victim, or this can be a victim on their own, or this can be a victim with the support of a domestic NGO. They would first report the crimes to the police and prosecutors in their new country, and they would assist in investigations. I would say of the cases that I've seen, 90% are triggered by some sort of information being passed to a victim or a victim's group of a perpetrator being present in the country. Maybe somebody sees somebody in a market or in a newspaper, or somehow gets a rumor that this individual is in the country, and that will trigger that victim to go forward and report the crime, report to the police what happened to them in their country. Oftentimes, and this is tricky now, the standard is for that victim, or the NGO working with that victim, to provide the evidence, locate witnesses, testify in trial. So it's left in the hands of the victim to work with the investigators to provide witness lists, give potential routes of evidence. But there's other options. This sounds very difficult, of course, especially if you're, let's say, a Syrian refugee, now that you have to get lists of people who were tortured with you. There are NGOs. There are NGOs who are working internationally. One of them is called CIJA, Center for International Justice and Accountability. It's based, I mentioned it before, it's based in Lisbon, Portugal. A former colleague of mine set this up. They investigate any crimes anywhere, basically. And most of these cases, these Syrian cases that have been prosecuted in Germany, have relied on evidence provided by CIJI, as well as the International Mechanism for Syria. So you have NGOs that are investigating crimes against humanity, serious human rights violations, and you can approach them, and then they can open up. And that this, again, does not involve any money. These are independently funded NGOs who get money from like European Union, US government, and they can open up an investigation and assist you. And at the end of this, if the idea of universal jurisdiction, or if you have some victim that you'd like to assist or something, I'm happy to put you in contact with CIJ. Second, migrants can mobilize public opinion in their new home country by informing the public about crimes that occurred elsewhere. For example, Syrian migrants in Germany organized together a group to promote prosecutions. So these Syrian crimes occurred. Victims were spotting it, spotting individuals responsible, pushing the government to prosecute these crimes, but then they united together. So you had a strong Syrian expat group, migrant group in Germany that were pushing the government, that were pushing the prosecutor's office to ensure that these crimes that occurred against them were prosecuted. They started, in fact, their own NGO, and they worked with local groups, informing the media, the government. So it's a lot of to do with national, with the victims groups that Syrians, be they Russians, be getting together in the country where they want to bring the case and pushing that idea through lobbying, through meeting with newspapers, getting word out about the crimes that occurred, but also that there's individuals responsible for those crimes present in the territory where the universal jurisdiction case can be brought. The third way is that migrants frequently seek meetings with elite officials. That includes judges and legislators, and they persuade them to act. They use personal narratives to humanize their conflicts. And in Roslin's case, testimony from Syrian migrants contributed to the Federal Court of Justice, Germany's highest court, issuing an arrest warrant against him in 2019. So it's making the news of what happened in your country and what's happening in your country public, but it's also making the direct contact with senior officials in the government who might be, you know, completely unaware that this situation occurred, or that this is actually involving people who are living and residing on that nation's territory, on Germany's territory. Fourth, many countries allow individual victims to launch private prosecutions. This is not at all known in the United States, where only public prosecutors can file charges. However, a number of countries allow the alleged victim of a crime, a private citizen or an NGO, to be a party in a criminal process with him instead of a public prosecutor. So in the Roslin case, several Syrian torture survivors and survivor groups were private prosecutors who acted along the public prosecutor. So in the US, you can only engage in an independent prosecution if it's civil. If you're asking not for criminal prosecution, but for financial remuneration for your crimes. So in the US, that's the only place a private prosecution can be brought. But in European countries, this private prosecution is allowed. So again, it's essential to work with a domestic non-governmental organization to assess what domestic laws are and what domestic laws allow. So in the end, it is migration, which is allowing the large amount of these cases to be heard in these courts. And by opening its doors so widely, Germany has made itself the main place for hearing universal jurisdiction cases. But another thing that Germany, Canada, and Sweden, and these countries that I mentioned before have is an acceptance of the legal principle, a refusal to restrict it, and a desire to enhance it, to strengthen it. So that commitment by the countries, Spain, Germany, Sweden, is essential. And there was a strong reluctance in Switzerland, but recently, I think end of last year, there was a decision, again, a Liberian case, and Switzerland is now moving to open more universal jurisdiction cases. So this is a whole other, really look at the individuals that you're looking to prosecute, see where they have a connection. If they have a vacation home in Switzerland or bank account in Switzerland, will you be able to open the door to bring a prosecution against that individual One recent blow challenge to universal jurisdiction was this November of last year. France's Court of Cassation, the highest court in France's judiciary, annulled the indictment of an alleged former Syrian agent who had sought asylum in France, and he was accused of complicity in crimes against humanity. This is considered a perverse application of dual criminality rule. So France's highest court held that the prosecution could not proceed under French law because Syrian law does not explicitly criminalize crimes against humanity. This is weird. I don't know what is going to be the final effect of this decision. This is the highest court in France saying Syria doesn't prohibit this, so we're not going to enforce it. We can't enforce a law on our territory that's not enforced on the territory where the crime occurred. No country has ever stated this. No other country has ever come up with this argument. So, what is going is this a sign that France is going to try to will begin to restrict its use of universal jurisdiction? I don't know. I don't think anybody knows. It's very shocking. I know that there are a number of universal jurisdiction cases waiting to be heard in France. And so they're very, I know that the lawyers are very nervous about what will happen. Under universal jurisdiction, what France did is a complete aberration. In asking whether the dual criminality rule has been satisfied when prosecuting an individual accused of crimes against humanity in Syria, a court should not be considering only Syria's domestic law, but ask if the offending behavior would constitute a crime against humanity under international law, under the international treaties, customary law, standards at the time that it was committed. If the answer is yes, then due process is protected. This approach has been confirmed by the way that the European Court of Human Rights approaches these cases. This is the first and only time that this argument has been upheld in any country that applies universal jurisdiction. So France has shifted the law back to the country of the perpetrator to determine what is a human right, which is really an aberration of the application of universal jurisdiction. One thing is also important is that in Germany, in Sweden, and Canada, it is not necessary for either the defendant, the person being charged with with international crimes, or the victim to be officially resident. France has now required, it's passed a law requiring that the defendant be officially resident in France in order for this prosecution under your universal jurisdiction. So in France, you've now become restricted in terms of just grabbing somebody who's flying in at the airport or going to a vacation home. They have to be resident in France. So this is a big push now and anger in the human rights communities in France, because they've been pushing for the French government to remove this legislation, but as yet, no action has been undertaken. So now I'm going to finish off. I looked very in depth looking for cases, Russian cases that may have been brought to any courts in Europe under universal jurisdiction. And I found some strange things. I found that Russia had actually pushed for universal jurisdiction in order to have prosecutions against Ukraine. What is happening now, and the place where universal jurisdiction in terms of Russia is most being heard, is in Ukraine. So Ukraine has passed a law, and I'm just looking for the exact date to give you. It was I think, in April or March of 2021. So while all the countries that are signatories to these treaties recognize the standards of these and can bring universal jurisdiction uh, cases under the torture law, Convention Against Torture, Genocide Convention, Crimes Against Humanity, all of these documents, the power for a country to bring a universal jurisdiction case is, of course, enhanced when they have their own national law stating we will prosecute under universal jurisdiction. So on May 20th, date's wrong, 2021, the Ukraine Bill 2689 was passed by the parliament. And it introduces amendments to the Criminal Code of Ukraine in compliance with rules of international criminal and humanitarian law. The milestone of this bill is that it provides for universal jurisdiction with regards to crimes of aggression, genocide, crimes against humanity, and war crimes. The legal decision was greeted very warmly by international experts, the way the law was drafted, the effect of the law. But it is significant because it allows the authorities in Ukraine to prosecute war crimes and crimes against humanity that have occurred during the conflict in Donbass and Crimea. The director of Human Rights Watch said the new law will fill a critical gap in Ukraine's legislation. It gives Ukrainian authorities some of the legal tools needed for the effective prosecution of war crimes committed in eastern Ukraine. So, in my opinion, there was an investigation opened briefly and not very successfully by the International Criminal Court. But the absence of the International Criminal Court's investigation into the events in Ukraine has resulted in Ukraine having to take its own steps in getting these crimes prosecuted. And this is the reason they pushed this new legislation through for universal jurisdiction. Like in Germany, the lack of another venue, another place for these, another court for these types of cases to be heard is the reason that universal jurisdiction has become the tool, the ultimate tool to get these cases prosecuted. So under international law, countries have the primary responsibility to investigate, prosecute, and punish those responsible for the crimes and provide redress to the victims. The absence of domestic legislation has been one of the key barriers in domestic accountability efforts. So further revisions to criminal procedure code in Ukraine are most likely needed to make the law as effective. So there's coming out of this examination of universal jurisdiction, you should have some idea of the steps that a group or an NGO or an individual would take in getting the case brought. But I think you should also have an understanding that where you go is so important, because you have to have not just the acceptance of universal jurisdiction as a legal theory. If you have the domestic legislation established and the domestic, like the Ukrainian law, pushing for universal jurisdiction and allowing it under its own national law, you're in a much stronger position in bringing these cases. So there's, of course, the hard work of going through, technically you could take a case in Croatia if you had a victim and a perpetrator in Croatia. There's nothing stopping you from bringing that case in Croatia. However, Croatia does not have a history of universal jurisdiction cases, or Bosnia does not have that. But are they open? Is the legislation there? The NGO that you partner with would have to tell you that. You'd have to examine it yourself. You'd have to see whether beyond the universal jurisdiction, there's a national political will to push these cases through the courts, and that the legislation is there established to allow it. So, in fact, there's places that haven't been tested. Finland, out of the blue, decided to prosecute with not out of the blue, with pressure from NGOs, but without a history, without the history that, for example, Germany has. They decided to take these cases and build them and start going forward on universal jurisdiction cases. So it's, as much as you can feel secure building a universal jurisdiction case in Germany or in Sweden or in Canada, you should also not rule out the option of building a universal jurisdiction in a new jurisdiction that doesn't have this history, but that may want to establish this history in their in legislatively and in their courts, judiciary, to begin practicing and prosecuting under universal jurisdiction. So is my final sort of concluding thoughts. Know your victims, know where they are, know the people you want to protect, where they fled to, and then where you think your perpetrator would be present, whether he'd come in or not. France is the only one that has that restriction of being a resident. In Germany, you can be just passing through. You can be a migrant. So that's essential, but it's also essential that you establish a relationship with an NGO in country, so that you have that support. If you have a victims group, that's excellent, because you have a base of other people who will have suffered, and who will be able to draw on family or friends or whatever the extended group grows in terms of getting evidence, getting witness statements of the crimes, the systematic crimes that occurred, that were perpetrated in the area that you're looking to prosecute. I have one final thought, and bringing those cases, I think it's, you know, while U.S. does not allow for universal jurisdiction, work with those U.S. rules, because those U.S. rules and sometimes are they're definitely more flexible than what we just heard with France a couple month ago when we talked about the U.S. cases. You had the case of Karadzic flying in to New York for a meeting, and immunity was not a reason to not prosecute him, and the fact that he was just flying in was not a reason to not prosecute him. So it's a lot of being creative in your legal approach and assuring that you have the contacts on the ground to push for these cases and to represent your victims and make sure that they have justice.